New Year. Welcome to the January 6, 2022 meeting of the Zoning Board of Appeals. This meeting is being held via video conferencing pursuant to Chapter 417 of the laws of 2021. And until further notice, all of the board's meetings will be held remotely. So we ask the public to continually check the town's website for updates and new information. There are also options on the website for public comments and to pre-register to speak on public hearings. So please consider that for all future meetings. If you wish to view tonight's live meeting only, please do not join the Zoom meeting and instead go to the town's website. If the live stream cannot be seen on the town portal, please go to the YouTube website and select the CTV Southampton channel. If you wish to be heard during a meeting but did not pre-register, please go to the town's meeting portal, choose the meeting group from the drop-down on the left, and you will find the information required to join the Zoom meeting. With that, I'd ask that you join me for the Pledge of Allegiance.
Pledge
I
allegiance.
pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We will be starting this meeting with the public hearings. We have applicants and members of the public standing by via Zoom webinar, which is being moderated by CTV. Charles Certain will mute the speakers until it is their time to give testimony before the board. Please be patient. If you find that you are having difficulties accessing the hearings, please visit the town clerk's meeting portal and click on the instructions link. Also, there are a few public hearings that will not be heard tonight, meaning that they're going to be adjourned. So please listen to hear when they will be rescheduled for. A reminder that applicants, agents, and members of the public speaking, other than attorneys, will be sworn in, will state their address for the record, and will offer their testimony as it relates to the application before the board. Board members who must recuse themselves from any application will state so on the record and will be removed from the meeting until the end of the hearing. Unless otherwise stated at the end of each hearing, all of these applications will remain open for written comments for all purposes until January 21st, 2022. These comments can be addressed to the board secretary, Candace, and sent via email, mail, and/or dropped off at Town Hall. With that, I would ask for a motion to approve the minutes of our last meeting.
Approve the minutes.
Ms. Kern,
Aye.
Ms. Burgess,
Aye.
Mr. Kelly,
Aye.
Mr. Daly. Mike, you're muted. We can't hear you.
I'm sure you'd much prefer that I have stopped my video than be muted, but aye.
Thank you. Mr. Tuthill.
Aye.
Mr. DeSenza.
Aye.
Chair votes aye. Minutes approved. And now we'll go on to adjournments.
Okay, we have a few here on this. The agenda under new applications, number 2 is going to be re-advertised, excuse me, for 120. Number 3, Bruce Klein will be re-advertised to 120. And under the re-advertised applications, Sandland Corp is going to be re-advertised for our April 7th meeting. Item 7 on the agenda, I will move to adjourn that to our July 7th meeting.
And number 7 on the agenda is 94 Dune Road, Holding Court. Is there a second?
Second.
Mr. Tuthill,
Aye.
Mr. Kelly,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Aye.
Ms. Kern,
Aye.
Mr. DeSenza.
Aye.
Chair votes aye. Adjourned.
Number 8 on the agenda is Gwendolyn Brewer. Move to adjourn that to our January 20th meeting.
Do we have a second?
Second.
Mr. Tuthill,
Aye.
Ms. Kern,
Aye.
Ms. Burgess,
Aye.
Mr. Kelly,
Aye.
Mr. Daly,
Aye.
Mr. DeSenza.
Aye.
Chair votes aye.
Okay. On the decision calendar, Fabio Dano,
You didn't do did you do number 10 already?
No, number 10, we're hearing.
we're hearing it.
Okay, great.
All right, so Fabio Dano, 95 Illinois Road West LLC and 85 Eastway LLC. I will move to hold those decisions over to our January 20th meeting.
Do we have a second?
Second.
All in
Yeah.
favor?
Aye.
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 Opposed?
Okay, Pamela J. Keld. I'll move to reopen the public hearing to accept written submissions.
Do we have a second?
Second.
Mr. Tudhill,
Aye.
Mr. Daly.
Aye.
Mr. Kelly,
Aye.
Ms. Burgess,
Aye.
Ms. Curran,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye, reopen.
Okay, now I'll move to close the public hearing for determination later this evening.
Do we have a second?
Second,
All in favor?
second,
Aye.
Aye.
aye,
Aye.
Opposed?
Okay, Kenneth Seif and Nicole Puel Seif. I'll move that that determination will be heard on January 20th.
Do we have a second?
second,
All in favor?
Aye.
Aye.
aye,
Opposed?
Gregory Liffin. I'll move to reopen to accept written submissions.
Do we have a second?
Second.
second,
Mr. Tudhill,
Aye.
Ms. Curran,
Aye.
Mr. Kelly,
Aye.
Ms. Burgess,
Aye.
Mr. Daly,
aye,
Mr. DeSessa.
Aye.
Chair votes aye, reopen.
And I'll move to close it for determination later this evening.
Do we have a
Second.
second?
second,
All in favor?
Aye.
Aye.
Opposed?
Okay, these following decisions, Edward Burke Jr. and Patricia Burke, LPD 4 LLC, Nice Licks Real Estate Holdings Development Corporation, and Scott Schlachter. Move that all be heard on January 20th.
Second.
All in favor?
Aye.
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 Opposed?
Okay, back to the beginning of the agenda.
Keith,
Well,
I'm sorry.
Excuse me, Mrs.
Go ahead.
Yeah,
Yes.
Did you
Susan.
miss 95 Inlet Road? I'm not sure I heard that. I know you mentioned Danio and 85 Eastway. I don't know if you skipped over that.
Well,
Do it
in case
anyways.
in case I did, I'll move that 95 Inlet Road West LLC, the decision be held over to our January 20th meeting.
Do we have a second?
second,
All in favor?
Aye.
Aye.
Mr. Secretary, did you say that number 5 is going to be re-advertised for January 20th?
I did that.
No? You did not? Oh, okay, sorry, I thought I heard that. I see that the attorney was actually checking in on the chat, so I thought we should tell him if that was the case, but
Not the
Nope.
case.
my ears
I'm
are
fine.
playing sick.
Anybody
Thanks.
else? Anybody else? All right. We'll go to the beginning of the agenda. Minor variance review. Item 1 is Richard Duran, 22D Gardeners Lane in Hampton Bays, Suffolk County Tax Map 900-321-5-24. Applicant requests the following relief from Town Code 330-11, Residence District Table of Dimensional Regulations, for a proposed 2-story dwelling with attached garage on a non-conforming lot. 1, a principal front yard setback of 30 feet where 40 feet is required. And 2, a principal rear yard setback of 52.3 feet where 60 feet is required, and any other relief necessary.
Board has jurisdiction.
Okay, so there's no public hearing on this one. Helen, it's yours. Do you want to make a motion?
Public hearing. It's a minor variance. And therefore, at the end of our hearing today, we'll have a decision on this matter.
Second.
Nope, nope, nope. Actually, we're waiting to hear from Suffolk County Planning Commission. So we're just gonna keep the record open and we'll do a decision on the 20th.
Oh, so it's actually getting adjourned.
No.
The record's gonna stay open for written subs and we'll do a decision on
Oh,
the
okay,
20th.
no problem. Okay,
Written subs, Katie, until when?
The 20th.
The 20th. Okay. All right.
did we
So
say
written
the
subs-
20th or the 21st?
The 20th.
20th, and there's going to be a decision, on for decision on the 20th as well.
Second,
All right. Ms. Burgess,
All right,
Mr. Daly,
aye.
Mr. Kelly,
Aye.
Ms. Kern,
Aye.
Mr. Tuttle,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye.
Okay, the next one we have is item 4, which is 808 Mecox Road LLC in Bridgehampton, Suffolk County Tax Map 900-116-2-4.4. Applicant requests relief from the following provisions of the town code for a proposed tennis court on a non-conforming lot. 330-11 Residence District Table of Dimensional, Residence District Table of Use Regulations for an accessory side yard setback of 23.4 feet where 30 feet is required. And 2, rear lot coverage of 25% where 20% is required, and any other relief necessary.
The board has jurisdiction.
Good evening, Kyle.
Good evening, Kyle Collins, KPC Planning Services, 116 South Country Road. 16, go ahead.
Okay, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. If you can tell us about the application.
Again, Kyle Collins, 16 Library Avenue, here on behalf of the applicant, 808 Mecox Road LLC. The subject property is located at 808 Mecox Road in Bridgehampton, having Suffolk County Tax Map number 900-116-2-4.4. Property is located in the R40 zone, having a lot area of 60,037 square feet, where 80,000 square feet is required. Accordingly, it's a non-conforming lot. It was created as a result of a subdivision that was approved in 1979. There was subsequent upzoning from the R60 to R80. The reason for the non-conforming lot status. A single and separate search was submitted with the application demonstrating that it has been single and separate. The subject of this application is associated with variances necessary for the construction of a reduced size tennis court, 55 by 115, which is proposed to be sunken at 4 feet below grade. The variances necessary to construct that are variances of 6.6 feet, which is a variance from the required side yard setback. Setback proposed is 23.4 feet, where 30 is required. Second variance is associated with the maximum required rear yard coverage pursuant to 330-77D. Proposed is 4,188 square feet, where 3,345 square feet is the maximum permitted, requiring a variance of 834 square feet. Again, I'll briefly run through the proofs here. I don't know the best way, share the screen. Is that okay?
That's fine.
Best way is to hit the share button.
There you go.
Was it part of a cluster subdivision or just a regular subdivision?
It was just a regular subdivision at the time. But there was a subsequent subdivision of a larger lot that was left as a result of that subdivision. That subdivision is further to the west, and I believe it was called the Summer Field subdivision. That, in fact, was a clustered subdivision, but this lot was not associated. It was created before that subdivision was approved.
So what was the zoning at the time of the subdivision?
R60.
Thank you.
Okay. Excuse me, that's not the right one. Hold on a second. Sorry about that. I got muted for some reason. Again, the subject property is currently being developed with a single-family house, as shown on the survey here, with the benefits of building permits for the house and the pool. The subject proposed tennis court is located to the rear, and the necessary variances are in this location is at 23.4 feet. And the rear yard coverage, as shown here, is the 100-foot required rear yard principal setback. And this is covering 25% of the rear yard where 20% max is required. The subject tennis court does comply with the rear side yard setback from the western property line, as well as double the required rear yard accessory setback, which is at 62.5 feet. Again, the property is being developed a single family home, and the tennis court is going to be located to the rear. So the impacts to the neighborhood relative to the streetscape, or as seen from Mecox Road, the subject tennis court will not be seen. And therefore, as it relates to the impacts to the character of the neighborhood from Mecox Road, there will be none. The subject, as it relates to the properties to the surrounding properties, again, I identified that both to the west and to the north, it either complies or is substantially greater than what is required from those setbacks. And hold on, I want to share another.
Kyle, before you go any further, just want to let you know, speaking for myself,
here.
we generally grant relief for 55 by 110 tennis courts.
Second.
He didn't hear it.
Hear me.
Oh,
Is it?
He will.
As it relates to the side yard setback, you'll see in this location, there are two flagpoles that run to the easterly property line, which is adjacent to the where the side yard variance is necessary. So in effect, there will be to the nearest property line to the east, there will be 63.4 feet from the nearest property line is developed with a single family house. There is right now planted, they're probably planted at 6 feet, but they've been planted over a year. There are substantial evergreen plantings that are probably about 8 to 10 feet now that surround the entire rear yard of the property, which provides a substantial buffer from the sunken tennis court. So for these two reasons, I think the buffer, as well as the location of the house relative to the road, there won't be any substantial impact to the character of the area. Again, as it relates to the second proof, are there other means necessary, or are the variances can be sought by another mechanism, given the location of the house and pool, and it's more related to the side yard setback and the existing lot with the proposed tennis court has been reduced to 115 feet, which is pretty much the minimum you can go and still have a usable court. Particularly
Kyle?
relates to that side yard setback.
Kyle, can you hear me?
There isn't another location as it relates to the required.
Kyle, can you hear us?
Setback.
Kyle?
And
Doesn't
then
seem like it.
third proof, are they substantial? I would say that the variances requested are both in terms of the rear yard coverage and the side yard setback, are both less than 25% of what the required setbacks are. And
Mr. Collins.
therefore, it is our position that they are not substantial. And then the last proof will be adverse impact to the physical environmental condition to the neighborhood. Tennis court has been designed so that it won't have an adverse impact. It is a type 2 action. Single family homes and associated accessory structures by definition are type 2 under SECRA. And which those said actions are, and I quote, which have been defined as have been categorically found as not to have a significant adverse impact to the environment. So our position again is the proposed tennis court and the requested variance will not have a substantial physical environmental impact to the neighborhood.
Charlie, is there a way you communicate with Kyle so he knows that
neighbor
I'll
have been in
I'll try to
discussions
chat with them.
under some
Okay.
perceived potential impacts to their property. That property owner is located at 45, who is located at this location. Let's see if I can highlight it, but it's in this location here. Actually, let me change my highlight to red because the yellow is not coming up. So can you not hear me?
Right.
we can hear you, but you're not hearing us.
Oh, I can't hear them. Why can't I hear them?
We've
That's
been
weird.
talking to
Why
you
can't I
for
hear them?
15 minutes.
Hello?
Can you hear us now, Kyle?
I can hear you now.
You can hear me
Okay.
now.
I don't know why I couldn't hear you. Can you hear
Okay,
me?
well,
Could you hear-
okay,
We
good,
heard
good. Now we
you.
can have a two-way conversation. That's always good.
Good.
All right, so I had jumped in while you were making your presentation. I didn't want to interrupt your train of thought, but I wanted to jump in to let you know that we, I'm speaking for myself, but we as a board approve when we consider tennis court applications, we consider applications for tennis courts of reduced size of 55 by 110, not 55 by 115. So we
Okay.
need it to be changed to 55 by 110, which will
Right.
change the percentage and change the percentage, and the survey would need to be revised, but that's what we do, 55 by 110.
Okay, that's the board's procedure? So in order to
when we
minimize the variances necessary.
Yeah, and to be consistent with how we handle tennis court applications.
Okay.
which Almost.
Whether
almost never do.
that
Yeah,
variance is a foot or 20 feet.
Right, well, I mean, and in this situation, we're really just dealing with rear yard lot coverage, and we're not talking about a big percentage, 20
Yeah.
to 25%, but still,
Okay.
any variance relief that is needed for a tennis court, when variance relief is needed, our board for several years now, quite some time, has said, we will, grant relief, and we will allow tennis courts of the size of 55 by 110, not any bigger.
Okay. Duly noted.
Other than that, the application is fine with me.
Okay. I just want to, if I could go back to share the square, well, I don't necessarily, I did identify the property owner that had some concerns about the variance. I think the representative may want to speak later on in the hearing. That property owner, as I highlighted on that last presentation item, is the owner of 45 Summerfield. And they were in conversations about some potential mitigation measures that the property owner of 45 Summerfield felt the tennis court may have issues.
Okay,
And they came to some agreement in order to try to resolve those concerns. Those agreements were to increase the depth from 4 feet down to 6 feet, to install a 6-foot fence along that property line with 45 Summerfield, which would include a sound dampening fabric treatment to it. And that would be along that property line with Summerfield. Also install an additional row of evergreen plantings along that property line with 45 Summerfield. Also to maintain the height of the trees to no more than 10 feet. And then there was another condition which can't be done under the village town code anyway, but no lighting shall be installed associated with the tennis court. So my client had agreed to do those items, and just wanted to let the board aware of that.
okay, that's great. And also, I want to correct myself, which is, I had mentioned the rear yard lot coverage, but in addition, there is setback relief, accessory side yard setback relief, 30 feet to 23.4 feet. So I'm hoping with the extra 5 feet, it will go to 30 feet to 28.4 feet instead.
Yeah, so the variance will only be 1.6 feet.
Right, right. And then my guess is the rear yard lot coverage may go down to 24%, but I guess you'll see how the percentage goes.
Great.
Reduction in size. And it sounds to me like there has already been negotiated the screening and to minimize the impact of the tennis court on the neighbor, which is a good thing.
Well, I'll let the applicant's representative speak for himself. I'm sure he's going to want to get on and talk about it as well.
Okay. In the meantime, any other questions of members of the board or Katie or Anthony? By the way, nice to see you, Anthony. Thanks for joining us.
I went to the property. It's very well buffered with evergreens. They're in beautiful shape. They're well maintained. So, there really is a good buffer there on all sides.
Great.
Yeah, I mean, I'll just note that there are no other tennis courts on any of the contiguous properties here in this area, and very few tennis courts in that general area. So, this will be a change. So I don't know if it's going to trigger other courts, people coming in, but I did notice that from the aerials.
If I may address that, I'll have to share my screen one more time. Well, I don't even need, let me share my screen one more time to address Mike's comment there. Hold on a second. Can you see my screen now?
Yes.
Yep.
So this is the subject property here. I can't seem to blow it up here. These other items are highlighted in orange are other, and they're less than 1,300 feet away, are tennis courts that have been granted previous ZBA decisions similar to those that are being requested here. There's another two up in the north. Now, Ms. Garvin had asked about the subdivision of this parcel here. It was clustered, so these are clustered down to 40,000 square feet. As a result of that clustering, they've created a size of lots that, in effect, from a practical standpoint, cannot accommodate tennis courts. So that's the reason why you don't see on those adjacent to the west any tennis courts because of the clustering of that subdivision. But
Right.
further to the west, you'll notice that there are properties that do have tennis courts and have been granted similar variances for those tennis courts in the rear yard.
Okay, thank you, Kyle.
Thanks.
Yep. And Kyle, we also had a building department comment that I just want to read into the record. You may have already seen it. I'm not sure. It's to Marjorie Riley, building inspector. And this is what it says. One, the survey prepared by Gary Ben, surveyor, dated January 11th, 2021, shows allowable lot coverage to be 15%. The zoning for this property is R80. The required lot coverage is 10%. The survey shall be updated to correctly indicate 15% lot coverage is based on 330-115D. 2, the single and separate search submitted with this application does not indicate the date from which the subject property has been in single and separate ownership. Those are the comments. And I don't know whether you've already addressed them.
I have not addressed them.
Yeah.
So, well, I'll take a look at those.
Okay.
Great. I'll address the first one only because this is a non-conforming lot, and pursuant to 330-115D, 4 establishes for non-conforming lots down to the 15%. It's a non-conforming lot. That's why it accurately reflects on the survey of 15% associated with this property, and not that of the R80. I'll have to go back and look at the single and separate, and I'll take a look and address that. I don't have that in front of me. Would not be able to address that at this time.
Okay. Yeah, if you just reach out to Marjorie about those 2 items and make sure she's satisfied.
Great.
And that's all I have. Any other questions? Okay. If not, is there anyone from the public who is waiting to be heard this evening on Zoom in connection with the application of 808 Mecox Road LLC? This is for property located at 808 Mecox Road in Bridgehampton. If you're waiting to be heard, this would be the time to let us know by raising your hand.
Michael is on.
Yep. Good evening, Michael.
Hi, good evening, members of the board, Mr. Chairman, members of the board. Michael Semlensky, 860 Montauk Highway, Watermill, New York, for the neighbor, Babek Yaragai. Kyle had mentioned that we have had a number of conversations regarding this property and some mitigation measures to address the tennis court. If I could just start, and what I would first start requesting of the board is that the board hold this matter open for all purposes. We only received copies, the mailings were sent out. We only received copies during the holiday break. I've had a number of times conferences with Kyle. Unfortunately, I've only had one opportunity to speak to the owner's attorney today in regards to issues. So I'd like to leave the matter open for, it seems like there's some unfinished business with the building inspector. So I'd ask this matter be left open for all purposes to the next hearing date for the board. Kyle's right in saying that my client has a number of concerns with this property, and most of it revolves around, this property. That the owners of this property, they made a choice, and they chose, and I'll read from the building permit application. They chose to build a one-family, two-story dwelling with a finished basement, including 2 bedrooms, an attached 3-car garage, covered front entry, exterior basement stair, all-season living room, covered outdoor sitting room, attached cabana with exterior basement, stair to pool storage, covered patio, second-story deck, roof deck, pool with spa, fence, porch, finished basement, pool house, pool, heated spa with a total of 9 bedrooms, and the septic field that is associated with 9 bedrooms. And this building permit and the building that's undergoing, this is not something that was done, years and years ago. This is something that was just applied for, and the building permit was issued in February of last year. So now it seems like they've had an epiphany, and when they applied for all of that, they somehow forgot to apply for a tennis court. And I think the board, knows that that's strange credulity, and they've basically built the biggest house they could possibly find, and now they're coming to the board looking for a tennis court that needs variance relief. And most importantly to my client, it's variance relief that engages into the rear yard setbacks, and that variance relief is what is required. There's a number of choices they could have made to move this tennis court into a conforming location. I will admit my client would prefer if there was no tennis court here. As Mr. Dunn raised, this neighborhood doesn't have tennis courts, and in the immediate vicinity of my client's property or any of those surrounding. And that's what my client would prefer. And I appreciate Mr. Collins has taken a number a good period of time with trying to address my client's concerns as far as mitigation goes, but we're not quite there yet. And I'd ask the board, it seems like he has other things to do, that we'd be able to adjourn this hearing to the board's next date, so that we can finish those conversations and bring a full mitigation package to the board that addresses all of my client's concerns and provides the applicant with a tennis court that's not going to be an issue with their neighbors in the neighborhood. So that's what we were asking for, if we can have that adjournment, because I think that there's a real issue here as to this tennis court and how they've gone about doing this, asking for it after the building permit, which provided for all those things that I listed at front.
Well, Michael, I appreciate your presentation. I understand that your clients want an opportunity to be able to review everything. That's a reasonable request. That having been said, I also think that the relief that's being requested here, mostly rear yard lot coverage relief, is not out of the ordinary in terms of what we grant relief for tennis courts. But that having been said, I want to ask Kyle. Kyle, do you have any objection to the public hearing being kept open until our next meeting?
Obviously, we prefer it to be closed. I think I addressed the issue with the percentage of lot coverage that was addressed in the building department's comments. I have reviewed prior to submission of the single and separate to demonstrate when in fact that it was since the change in zone in the early 80s, but if we need further clarification of that would be fine. I don't think there is any other materials that the board needs that has not been submitted to date to make the decision. So I would request that it be closed for decision.
Okay. So,
Mr. Chairman, if I may, I mean, this is, I know the board, having spent a long time in the building, I know very well the board's past dealings with tennis courts and things like that. However, this property is particular in and of itself, in that the applications that were made for the building and development on the property were done so, and they've basically been done, and they've been segregated into two pieces. And one of the tests the board has to go through is whether or not this is self-created. And applying for a tennis court where it's being applied for right now is a completely self-created hardship. And it's not one that the board should look the other way on, because they have, gone through the entire, and I'll spare the board, because I know these meetings run long, but they've applied for a whole litany of things pursuant to their building permit. And only then do they come in 11 months later and seek to add a tennis court in afterwards, and then say, well, we can't move it anywhere else. We can't move it anywhere else. We can't move it further on the property or further up the property to reduce the size of the variance, because all of that other stuff already exists. And I would say that is a distinguishing and differentiating characteristic of this property and this property alone that the board really needs to consider. And I would again request that the adjournment be open. And I would just remind the board that town hall's been closed a number of the days of the time that we've had notification of this variance application. And I don't think it's unreasonable to keep the entire thing open until the next hearing, because of the lack of ability to get into town hall and the lack of notice to my client on a short notice to try to see exactly what the terms of this application are, and to make an informed decision on what's going on next door to them.
Okay. Well, I appreciate everything you're saying, Michael. I'm hearing both of you. It's going to be up to the board. You need 4 votes as to what we're going to do here. I mean, basically the choices we have, I think, are keep the public hearing open until our next meeting, which Kyle does not want, because I'm sure his client wants to move the application along, versus us closing and leaving it open for written subs, which we will be doing anyway. And then, Michael, you will be submitting everything you've outlined, but maybe in some more detail, whatever detail you wanted in a written submission. But I also want to mention there was a discussion of whether, the neighbors, the discussions between the applicant and the neighbor related to trying to deal with the screening and impacts on the neighbor can be more fully addressed. And I think, for me, I really would rather have you come back to find out exactly what's being proposed and whether the neighbor's satisfied, because I want to encourage applicants and neighbors to work things out and not leave things where there ends up being hostility between the applicant and the neighbor after the fact, when it sounds to me like there have already been discussions happening that are going in the direction of an agreement. But that's just me. So I think my inclination is leave it open until the next meeting. So I'm not sure where my colleagues on the board stand. I'm just wondering.
Adam, I'm inclined with you to leave it open, to hold open the public hearing until the next board meeting, which is the 20th.
If I may.
Sure.
The applicant or the adjacent neighbor's argument is primarily solely on that it's a self-created hardship, which, as you guys know, in and of itself is not a reason for the denial of the application. Mm-hmm. And as I had stated, there was an agreement associated, 5 points that were agreed to. Mike did not share that the reason for the objection at this point to those 5 points is that 2 of the items, one of the items is to maintain the height of the subject trees at the 10 feet, which we agreed to. The applicants or the adjacent neighbors representative wanted that secured by a covenant. The current owner of the property is in contract to sale of that of the piece of property. Given that they're current in contract, it becomes problematic to further encumber this property through a covenant, and that's the reason why they are currently objecting to the application. Absent the covenant, my client does not have a problem if the ZBA conditions it, and that condition of the ZBA would be fine. The only problem is the fact that they're currently in contract and becomes problematic to put a further covenant on this property.
And the issue
Even
of the
more,
covenant is really between the applicant and the neighbor, and not something we can do much of anything about. I'm sorry to say. I mean, we can put a condition in the decision. That's
The
completely
ZBA could put a condition that the screening has to be maintained at a certain height. You know, I mean, by the applicant, by the future owners of the property.
We'd be happy to have that as a condition of the ZBA decision.
But it just seems
All
to me we're having all this discussion about these issues, and it's not resolved. And a 2-week adjournment. We're not talking about 2 months. A 2-week adjournment to give Kyle, you, and Michael an opportunity to iron this out and come back with something that is an agreement. Seems to me to be time well spent, despite the fact that, yes, it's a health self-created hardship is not a rationale in and of itself for us to deny an application for a variance.
Mr. Chairman, do we have
Yes.
anybody else from the public that would like to speak on this matter?
Well, why don't we ask? Is there anyone else waiting to be heard this evening in connection with the application of 808 Mecox Road LLC? This would be the time to let us know if you're waiting to be heard by raising your hand.
See no hands.
No hands.
All right, Susan, you have a motion?
I have a motion to adjourn this hearing until January 20th.
I will second that motion.
Okay, Ms. Kern,
Aye.
Mr. Tudhill,
Aye.
Mr. Daly,
Aye.
Ms. Burgess,
Right.
Mr. Kelly,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye. Thank you both so much. We will.
Thank you very
see
much,
in
board.
2 weeks.
Thank you for your time. Have a good
thank you,
evening.
everyone. Have a
Happy
good
New
night.
Year.
You as
Happy
well.
New
Happy
Year.
New Year.
Okay, item 5 on the agenda is Alice Greenwald, 148 Edgemere Drive, North Sea, Suffolk County Tax Map 900-31-2-2. Applicant requests relief from the following provisions of the town code to legalize a wood deck on the north side of the dwelling. Front. 1, 330-83A, 4 yards to allow a deck higher than 1 foot above ground level to be located within the required front yard. And 2, 330-11, residential districts table of dimensional regulations for an accessory side yard setback at 8.7 feet, where 10 feet is required. 2, to legalize the wood deck on the south side of the dwelling rear. 330-11 for an accessory side yard setback of 5.6 feet where 10 feet is required. And 2, 330-76D, placement of accessory building structures and uses in all districts. And 330-83C yards to allow a portion of the deck to be located within the required minimum and total side yard for the principal dwelling. And 3, to legalize the outdoor shower. 330-76D, placement of accessory building structures and uses in all districts. And 330-A3C yards to allow a portion of the outdoor shower to be located within the required minimum and total side yard for the principal building, a non-conforming lot, and any other relief necessary.
Board has jurisdiction.
Good evening, Carl.
Good evening, Mr. Chairman. Good evening, members of the board. I'm going to share my screen with you. Just let me. Let me know. Can you see that?
Yes.
Okay. So as the secretary mentioned, this is a request for relief for various existing structures. A little background on the property. The property is part of the Roses Grove subdivision, which was filed on August 21st of 1926. The lot sits currently in the R15 zoning district and is non-conforming in 2 aspects. First, it's 6,905 square feet in size when 15,000 is permitted under zoning. And the lot width is 60 feet at the front, 47 in the rear, when the minimum under zoning is 100 linear feet. So it's blended in great respects with respect to its nonconformity. It's located on Edgemere between Hearn Place and Oak Grove. As noted, we are asking for several relief. First, the first relief we're asking for is for this front wood deck. The front deck is 9.2 feet from the front yard, where 40 is required under the R15 zoning. It's a structure over 1 foot. It's actually 4 feet above height. So we need relief in that sense, and because it is in the front yard, required front yard. And it has a side yard setback of 8.7 feet, where 10 feet is required. Moving along to the shower on the western side of the property. The shower meets accessory side yard setbacks, but because it's within the total side yard setback under the zoning district, which is 25 feet, actually 22.1 feet here, given an earlier variance, but I'll discuss that momentarily. And here the total requested side yard is 18.7. So we do need some moderate relief there. And finally, this back deck, the relief we're talking about is this portion here, which is 5.6 feet from the side yard, where 10 is required under zoning. Finally, there's a shed in the backyard which sits right on the line, and I'm going to address that later on in the presentation. So first, to the relief we're requesting. It's not self-created. My client purchased this property just before the pandemic. With all these structures in their current place. They had been in place for 15 years without incident or complaint from the neighborhood. It fits with the character of the community. If you note around the area, and I'll pull up an area map now, specifically right on Edgemere, each of these homes have structures that exist well within the setbacks required under zoning. First, next door at 78 Hearn Place, the home is actually 6.1 feet from the side yard bordering my client's property, and only 17 feet from the front yard with Hearn Place. Going to the eastern side of my client's property, 150 Edgemere has a side yard of 3.3 feet with its adjoining neighbor to the east. And to that adjoining neighbor to the east, that's 32 Oak Grove. Its home is 15 feet from the front yard, from the road, again, when 30 is required. This subdivision, as you know, is very old, and the lots are very non-conforming, so you create these inconsistencies with zoning are incredibly common throughout. So this relief is not going to affect the character of the neighborhood. One, it's been there for 15 years, and two, it's fully in line with this placement of other structures in the area. I should note that the subject home was approved, the CO, which was issued in 2000, the last CO was issued in 2005. Under this survey, which is in two sections, forgive me for that, but this is the pertinent part. And you'll note that the home is approved and it's as a pre-existing nonconformity with 15 feet from the side yard. You'll also note that in that original approval back in 2005, the deck, which we're asking for relief for, was there. So for some reason, the town issued a CO acknowledging the existence of this deck within in its current placement. Back,
which is not unusual, Carl, as you know.
It does happen, but I just recognizing the town has seen this and that it's been that way for at least 17 years.
Mm-hmm.
Similar relief has been granted by this board in the area, just around the block at 18 Oak Grove in 2001. This board granted relief under variance D10878 to reduce the front yard setback from 40 feet to 20 feet, a 50% variance. From the side yard from 15 feet to 12.3 feet, and a shed on that property, a setback from 10 feet to 5 feet. So all of that, I'm just trying to relay to this board that the community, the character of the community is not going to be in any way detrimented or affected, both by pre-existing nonconformities and by variances granted in the area. This sort of placement of the home is largely consistent with the character of the area. That also plays into adverse impacts. Given the character of the area, given that these sort of structures exist, given that this has been there for 15 to 17 years, it's not going to have an adverse impact on the neighborhood. And there are no other means, obviously. These are existing structures. And again, I just want to point out that my client inherited these structures, and we have not been summoned by the town. We have not been cited by the town. She is taking this relief on this action on herself to legalize the properties, to make sure that everything's legal on her property.
Which is a good thing, and which I commend.
Thank you.
So when she bought the property, was she represented by an attorney?
She was represented by me, and we were aware of these. We had a. Let me explain myself. We had a
Truth,
the
the
CO
truth comes
was
out.
there was a updated CO was required in the contract. We were aware of these nonconformities, and rather than, we had issues with the bank as far as the deadline and rate lock issues, and rather than canceling the contract, which we were entitled to, she decided to take it on as with these obstacles. Again, she didn't have to come get a variance. She could have lived with it as it was, as previous owner did for 17 years. But when we closed, we decided to move forward and seek this relief.
Right. And
but there wasn't a provision in the contract requiring an updated CO. So these were all.
I understand, and I only bring it up because I know you mentioned it wasn't a self-created hardship, but this purchaser took on this issue by taking title with it without the approvals for this.
She did, and she's doing but she didn't have to come to this board to seek this relief. I mean, technically, she could have lived as it was. And as you know, Adam, there's a lot of considerations that go into closing transaction, and this was one consideration out of many. As far as
malpractice policy, no problem.
What did you say, Brian?
I'm teasing with you, Mr. Benacasa. I said, good malpractice policy would be fine.
No, this.
Okay, so next I just want to go into the fact that these are as-built structures built at least based on your testimony, at least 17 years ago. So presumably they were built by a previous owner or contractor, and on behalf of a previous owner, and because of that, you wouldn't be able to provide any information as to how the structures went up without permits?
No, I don't have that information, no.
Okay, is everything going back 17 years? Is the outdoor shower 17 years? Is the shed on the property line going back 17 years as well?
So the rear deck is going back 17 years. These are 15 years. These were put up.
Okay. But there's
Same
no
with
one
the
to
shed.
ask. There's no one to ask about how they went up. So I just want to make that clear, because as you know, we usually ask what happened and how structures went up without permits, because we don't want people putting up structures without permits. So anyone watching who's interested in this, if you have any doubt, when you want to build something, please ask the building department, because it would be preferable to do that to end up dealing with it after the fact.
So, yeah, anticipating that question, I did actually reach out to counsel in my preparation for the previous owner, and she was unable to get that information from her client.
Yeah. Okay.
We appreciate the effort.
I made an effort.
We do, and appreciate the fact that this property, your client is trying to legalize and trying to address these issues that were not addressed by someone else. Okay, so we did have a couple of building department comments. I'm not sure whether you've seen them already, Carl, but I just wanted to read them into the record. This is from Marjorie Riley, building inspector. And she writes, in order to confirm the setbacks and pyramid compliance, the survey with pyramid diagram shown, prepared by John Barilski, last dated September 8th, 2021, shall be revised to make setbacks and elevation data legible. Some of the ones, I guess the datum on said survey, are difficult to read and partially illegible.
That's been done. We have the updated survey in the package.
Okay.
Yes.
Good. All right. And that was it in terms of comments. And well, I'm not sure if are there any other questions of members of the board or Katie.
Yeah, I have a question. We didn't advertise this for the shed, and the prior survey doesn't even show the shed there. So Can you explain about the shed?
The shed is not, it's not an issue. If we can ignore the shed, and my client's fully willing to move the shed.
Well, we're gonna need it removed,
shed was-
removed to conforming location, and we're gonna need that shown on the survey. if
Okay,
that's-
we can do
yeah.
that, sure.
Yeah.
Carl, the survey that appears to be updated here shows the shed in a different location from the survey that you have online. It shows the shed in the southwest corner at 10.2 feet and 9.7 feet.
Yeah, the shed was moved twice, actually. But like I said, my client is willing to move the shed to a conforming location and will provide an updated. The shed was in the location you see here, and then it was moved and then moved back.
Yeah.
And but the shed is not a material aspect of this application, so she's
Okay.
more than willing to move.
It's no problem, but if you can, have the new survey just showing where the shed's moved to at a conforming location, that would be greatly appreciated.
Of course.
Okay. Any other questions? Okay, if not, is there anyone from the public who is waiting to be heard this evening in connection with the application of Greenwald? This is for property located at 148 Edgemere Drive in North Sea. If you're waiting to be heard on Zoom, this would be the chance to let us know by raising your hand.
See no hands.
Okay. And Carl, I also forgot to ask you whether you heard from any of the neighbors.
I did not, no.
Okay. Okay. All right. Mike, it is yours.
Okay, I will close this hearing, except for written submissions, until January 21st with a decision on February the 3rd, 2022.
Second.
Mr. Daly,
Aye.
Mr. Kelly,
Aye.
Ms. Burgess. Ms. Burgess, Helen. Maybe she's muted. Okay, Ms. Kern.
Aye.
Mrs.
Oh, I
Tuthill.
said aye.
Oh, okay, didn't hear you, now I hear you. Okay, Mr. Tuthill,
Aye.
Mr. DeSessa,
Aye.
Chair votes aye. Thank you so much, Carl. Have a
Thank
good
you
rest of your
all.
night.
Happy
Good
New
night.
Year.
Happy New Year.
Item 9 on the agenda is Grant Werner, Brett and David Moore applicants. 10 River Avenue in Eastport, Suffolk County Tax Map 900-351-2-23. This is held over from our October 21st meeting and adjourned from our December 2nd meeting.
Okay, good evening, Mike.
Good evening, Mr. Chairman, members of the board. This is the second time that this has been heard by your board, and there's been some submissions made since the last hearing. Just to bring the board up to speed very quickly, this is an appeal of a determination of the building inspector in issuing a certificate of occupancy for a multiple dwelling use on the premises. My clients are the next door neighbors. When we reviewed the file, it became apparent that the documents that were submitted in support of the C of O application were inadequate, to say the least. One of the documents was an affidavit which was some 14 years old by a deceased gentleman, attesting to the fact that the property had been used as a multifamily property. No details, no specific facts, no exhibits, no attachments, nothing at all, really. And then there was a self-serving affidavit of the owner. We've briefed that already back in October when we first appeared before you, and that's been put in writing. I urge the board to review that letter with the attachments, because we went into the building department file. And what's most compelling, I think, in this case is the fact that the owner actually made an application for a building permit in 1972 and for a certificate of occupancy to legalize one of these cottages. The property, the owner contends, benefits from a principal dwelling use, a main house with an apartment in the house, and 2 cottages in the rear of the property. There was a certificate of occupancy issued for the principal dwelling, the main house, the apartment, and the 2 cottages. It immediately became apparent that because of that 1972 building permit application and certificate of occupancy that had been previously issued, that one of the cottages was not to be used for habitable purposes at all. The application had been granted to renovate a pre-existing frame barn into a playhouse. And the applicant, the owner, I understand, has admitted that that the CO that we're talking about here was issued in error on that basis alone. They've agreed that it should be amended to remove one of the cottages, one of the habitable dwellings in the backyard, the rear yard of the premises, because it benefits from a pre-existing CO for this playhouse from 1972. Another interesting thing about the building permit application in 72 was the fact that the owner, the then owner, Mrs. Werner, when she filed the application, indicated that the use of the 2 buildings in the rear yard were frame barns. There's a certificate, there's a survey in your file that indicates that the buildings as then used in 72 were 2 frame barns in the rear yard of the property. Then this application was made with these affidavits, and somehow out comes a CO granting the principal dwelling, which we don't contest clearly is a principal dwelling, an apartment in the main dwelling, and then these 2 cottages. Clearly, there was just no proof in the file. There's been no affidavit submitted that would suggest that these 2 cottages in the rear yard benefit from any pre-existing non-conforming vested right to be maintained as habitable dwellings. We've also reviewed the Suffolk County Health Department files. There's no septic systems that have been approved for these units. If you look at the affidavits that have been submitted, there are now 4, in addition to Mr. Hume's testimony at the last hearing. You have the affidavit of the owner, Mr. Werner, the affidavit of the deceased gentleman, Mr. Smith, and that 2 new affidavits have just arrived as of approximately 3 o'clock this afternoon. One is not notarized. I assume it's going to be notarized. Ms. Marbury, who states that she resided for a month or 2 at the property back in 1971 or 1972. She can't recall, and that her recollection was that there was a cottage in the rear yard being used. She doesn't say which cottage. We know that one cottage is no longer going to be used as a cottage because it's been agreed that the CO was issued in error. As an aside, there was a 3rd cottage, which was a trailer actually, that's been removed from the property. We don't know if she was referring to that building. That affidavit is completely lacking in any detail. No surveys referenced, no photographs. Very, very vague in its contents. And then there's another affidavit that just appeared this afternoon. Again, it alleges that sometime in the mid-1970s, this gentleman resided in the apartment in the house, and he seems to recollect that there was a cottage in the backyard. No detail. There's no photographs, no names of anyone who resided there. In this particular case, this file is so lacking in any specifics. Typically in a case like this, you'd get some sort of details as to what was there, what was the floor plan, what's the configuration of these buildings, who resided there, or have a lease. I have photographs. Here's someone standing in the garden next to the cottage. Here's the tenant. There's nothing. This is complete and utter hearsay. And if you look closely at the file, what you'll see is that this is probably one of the thinnest applications for a pre-existing CO, I think, that's ever been brought before this board. And I don't think it's been cleaned up since the last hearing. We were told that there was going to be more submissions made. We did get a letter this afternoon at about 3 o'clock this afternoon, which we'd like to respond to, if we can be given a week or so just to respond to that. I think at this point, unless there's anything else, we've finished our case on the appeal. We've put everything in before you. I think your file's complete. We'd like to move to a determination. And again, we'd like just a short period of time to respond to anything new that's said tonight by the homeowner, who I understand is represented by Mr. Hume. We've had a good relationship throughout this, and Mr. Hume and I, and you know, if he needs time to respond to what we put in, fine. But we'd like to proceed to a determination at the board's convenience.
Okay, thank you for your comments. And we did get your submissions, Mike, but we didn't get whatever was submitted. At least I didn't get whatever was submitted this afternoon. So, Jim, maybe you can give us an update and let us know about what where things are.
Sure. I submitted earlier today, because it took me a while to track down the people that I submitted affidavits for, a letter, as well as some documentation, as well as 2 sworn affidavits, one of which hasn't been notarized yet, because it turns out the signer of that is in Florida, but I should have that document back. It's signed, but I should have it back notarized shortly, and I'll submit both of them, both of the originals at that point in time. I submitted everything to council, to the clerk, and also uploaded everything through the zoning board portal this afternoon. So hopefully it is somewhere in the system. But at Candace's request, I will submit, make it as a written submission subsequent to today, with 10 copies, and meet all of those requirements. I obviously strenuously disagree. Before we go any further, I believe my client, Mr. Werner, is in the waiting room. And if he could be let in, is that possible?
Sure.
Okay, being let in.
Thank you. He's been listening with interest, but he would like to be seen as well. So
No problem.
See his name. I don't see his name.
is it under Kathleen Werner, perhaps?
I don't see anyone.
Because he has been listening and watching.
Yeah, I see him.
So.
Coming now. Okay.
Yep. There we go.
There we are. So you'll certainly be able to read it yourselves, but just the gist of my written submission is we did submit 2 affidavits from people who actually resided on the premises in the early to mid 70s, but had awareness of the property back as far as the middle to early 1960s. And they both verified that at the time they were there, and at the time that they're aware of, that this property consisted of a main home with an apartment within it, and a second cottage in and I believe what they referred to in their affidavit is the rear cottage. And to their knowledge, the structure in between the main house and this rear cottage was what has been commonly referred to as a barn. It did later become converted to residential space, but through the process of getting the CO issued that we had issued from the building department, it was agreed that we would return that structure to an accessory structure of the kitchen, and cooking facilities have been removed from that building, and it is no longer in condition to be a separate residence. And in fact, we are not and have not been seeking that use for that particular building, and we're as surprised as Mr. Walsh may have been that the CO that the building department actually issued characterized it as such.
Is that, Jim, is that the 1-story cottage or the 2-story cottage?
It's the 1-story cottage. It's
Okay.
the one in the middle. It's the
Okay.
one in the middle.
So
The
you
other
think
thing
this,
that,
you think the CO should read the two-family dwelling, which would be the house and the
Yes.
apartment, and then a two-story cottage?
1.5 stories, actually.
1.5 stories, okay.
Yeah, because and that building it's kind of a space with a loft above. It's not really a full second story.
Okay.
I think that we've established through a comparison of aerial photographs and surveys that the footprint of all of the structures that are there now are exactly the same as they were from the early 60s and perhaps even back into the 50s. Although I was unable to identify an aerial photograph that was clear enough to demonstrate that. I think our affidavits and the testimony of my client at the last hearing has demonstrated that prior to the law change in 1962, there was in fact a two-family house and a residential cottage on this property. And the reason why the 1972, as I pointed out in my written submission, the 1972 code change is important, and why we need to predate that is that prior to 1972, these accessory or other secondary cottages on properties were permitted. It was only in 1972 that the law changed that eliminated the ability to have and maintain these secondary residential structures on the property, on such a property. I would point out that in my discussions with the building department prior to their issuing the CO that they issued, that they found that argument compelling. And in fact, was one of the reasons why they were willing to issue the CO, identifying at least one of the cottages as residential in nature. And again, we're talking about the rear cottage. So for a substantial period of time, and from a time when I believe it was legal to have been structured that way, this property had a two-family house and a separate 1.5-story residential cottage in place, and what we're seeking to maintain.
Is that in your written subs, Jim?
Yes.
Okay.
So both sides have submitted written subs. Jim, we haven't seen yours yet, but I guess the other question I wanted to ask is, other than, Mike responding and then you're maybe responding to his response, whether there's anything else, and the affidavit that needs to be signed and notarized, whether there's anything else that either side would like to submit.
No, I would join Mr. Walsh in asking that you close the hearing other than those written submissions.
Okay. All right. So this is one of the, when we deal with these applications where there's an appeal of a determination in terms of a building permit, and certificate of compliance, whatever the case might be, or CO, that we take a look at everything that was submitted by both sides to really just take a second look at what transpired here and what the facts are. And that's exactly what we're going to do. I know that there are we have a bunch of people who are on the Zoom that may want to say a few words before we close. Also, there may be other people who are on watching that may want to be heard. But anyway, but before I do that, any other questions and members of the board to Mike or Jim?
I'm sorry, I have another question. Jim, my ears are clogged. So your testimony, or what you said, was that the playhouse was converted to a cottage. Is that what it was? The playhouse was converted to a cottage, and the building department had suggested that that was permitted?
No.
What was converted to a cottage?
There was the middle building was CO'd as a playhouse in 1970 something. Right. Subsequent to that, without the benefit of any permits or anything like that, the playhouse was converted to a cottage.
Okay, that's what I said.
And as part of our processing the the pre-existing CO that we ultimately got from the building department, we agreed with the building department that we did not have the right to keep the playhouse cottage as a cottage. And it reverted back to an accessory non-residential structure. But the mistake that the building department made was when they issued the CO, they still carried that playhouse forward as a legal cottage. We're not asking for that to be the case because we've already agreed with them and they've already indicated to us that it wasn't and it shouldn't be.
No, but what was the second structure that you said was allowed?
The second, there's the most rear 1.5 story structure was in the 60s a cottage and is still a cottage.
But did it ever say, did we ever have a CO that said cottage?
No,
Okay, so you're maintaining it's pre-existing,
yes,
even though it never had any COs because it was prior to this time where you say more than
the
one
code, yes,
dwelling was allowed. Okay,
correct. That's exactly what I'm saying. Thank you.
okay.
May I just add something, Ms. Garvin? Mike Walsh here.
Sure. Yeah, sure.
This issue of the second cottage, we've eliminated the first cottage because we know it's a playhouse and everyone seems to have agreed that the CO was issued in error and will be amended in that respect. Insofar as the second cottage is concerned, I believe it's Mr. Hume's argument, if I understand it, that sometime between 1957 and 1972, the second cottage was converted from the barn, which was depicted on the 1972 survey building permit application survey. It was converted between 1957 and 1972. And that between 57 and 72, the zoning ordinance, which then existed, the 57 zoning ordinance, permitted multifamily uses in the zone in which the property was located. I'd point out that initially Mr. Hume said that it was located in the B residence zone, and now in his letter today, he said it was in the C residence zone. I don't believe it makes much of a difference. But I think we should clear up what zone it was actually in. I believe it was in the B zone between 57 and 72. Now, in 1972, I want to be very clear about this. There was a building permit application made when the 1972 code was then effective, because it was effective in May 1972. The application was made June of 1972, and it was signed by Mrs. Werner. And there was a survey attached to that application. And there was a statement made in that application as to the use of these buildings. The survey indicated they were frame barns. An application was made to convert one of those frame barns into a playhouse. There was no application made, and there was no building permit issued or CO issued for the second frame barn in June of 1972 under the then existing code. So what your building permit file clearly indicates is that in 1972, under the 72 code, when that permit application was made, there was a statement made by the owner that the then use was a frame barn, because that's what the survey depicted, and there was no application made whatsoever for that second cottage. We're now being told that sometime between 57 and 72, the code somehow permitted the second barn to be converted and used as a one-family dwelling. I don't see anything in Mr. Hume's submission that briefs that particular point and tells us what section of the 1957 zoning ordinance he was referring to, or what sections of the 72 zoning ordinance he refers to. I would suggest it would be helpful to the board if we both brief that point, within the next week or so. If Mr. Hume chooses to do it or not to do it, that's up to him and his client. But I think it's very important for the board to know that. What's the position of each of these parties, my client, the appellant, and the respondent, Mr. Werner, as to what section of the 57 code gives the right of this property owner to argue that there was some sort of a conversion between 57 and 72 that vests in him a right to maintain this second cottage as a one-family dwelling. I think that's the legal issue that the board is going to have to grapple with. I don't believe that it's really been explained yet in the submissions that have been made by the property owner. I would suggest that that be fleshed out a little bit more. It would be very helpful, I think, to me to understand how that conclusion is being asserted in this particular case. I personally don't see it that way. I believe that between 57 and 72, multifamily uses were prohibited on this site. They continued to be prohibited in 72 when a building permit application was made. That's why the building inspector back in 72 did not grant a permit for the habitable space in the cottage that was applied for. He gave them a playhouse and prohibited the building being used for either sleeping purposes or cooking purposes. That's the final point that I will make, but I think that the law supports our position on this appeal respectfully, and we look forward to making an additional written submission within whatever time you want to give us.
If I could just comment briefly on what Mr. Walsh just indicated. The only thing that happened in 1972 is that the building inspector issued a C of C or a C of O for the converted playhouse. There was no commentary or comment on any of the other uses, the main use with the accessory apartment or the other use. Mr. Walsh is correct that the survey that was presented in 1972 did show both of those structures as barns. However, if you look carefully at the survey that was submitted in 1972, it was the very same 1964 survey that showed the existence of those structures back in 1964. The building and permit application was submitted by a layperson without advice of counsel or anything like that. She just had an idea to do something with on her property. In sharp contrast to that very narrow application is the fact that we have two people who actually lived on the property who specifically have said that there was a residential cottage in the other structure. But I'll be happy to brief that, to comment further on that legal issue in writing subsequent to today's hearing, to whatever schedule the chairman may set.
Yeah, well, and Jim, that's what I'm saying, but I do agree with Mike. Both of those things are necessary because I think obviously it's persuasive to hear, from people who live there and people who can,
Right.
can state that it actually was used that way, but it also has to be stated whether that was a permitted use, just because
Right.
people are testifying that they lived there doesn't mean that it was allowed. And that's,
Right.
that's where, that's the part that I'm getting to, whether or
Okay.
not.
I'll be happy
Mike.
to take another stab at that.
Thank you.
Okay, any other questions or members of the board of Jim or Mike? Okay, I know there are some people who are here on Zoom that may want to say a few words. Well, want to ask if there's anyone who'd like to speak to us. Okay.
It's
Okay.
me?
Yeah, I think so. Just if you could just state your name and did I previously swear you both in?
Yes.
If I previously swore you both in, you're still under oath. You can just both state your names.
Brett Zado.
Leah Zadow.
Okay. Thank you.
All right.
What would you like to tell us?
Right. Thank you for having us. Just going to start by saying we've been here since 2014. Certainly nothing personal against Grant Werner. But now that this has come up, we were in our 20s when we moved in, so we didn't realize all of the legalities and everything that went on. Over the years, there's been multiple properties that actually have had zoning changed without hearings. I've been through the variance process twice myself, so it was a little disturbing in our last meeting to find out that the lawyer and the building inspector just decided this during COVID in an office meeting without having a public hearing. The neighborhood is definitely growing, changing. There are a lot of families, and it's just upsetting that finding out that this was never legal. And now all of a sudden, because it's been happening so many years, that all of a sudden it would make this legal. And just as far as raising a family here and living here and looking at the futures, just got a new tax bill, it went way up, that I really feel that it's concerning moving forward to have multiple dwellings in a neighborhood. I don't know if you've driven through personally or have seen the neighborhood, that, we're really a single family home neighborhood with family and young children moving in.
And we can't even get a school bus for our children in front of our house because the roads are too narrow and then we have a wooden bridge, but.
Right, that's true too. We don't really have access in and out of the neighborhood at this point either, so.
Yep. I just want to make sure you both were previously sworn in and spoke at the last hearing.
No,
No,
I
we
couldn't
were not.
raise my hand. We weren't in the link to
Yeah, I
correct.
gotta swear you both in. If you can state your
Yeah,
name and
where
address
was
for the record.
That's why I raised my hand before.
Yeah.
Okay, you can state your names and addresses, please.
Leah Zadow, 14 Pleasant Valley Road, Eastport, New York, 11941.
Brett Zadow, 14 Pleasant Valley Road, Eastport, New York, 11941.
And do you both swear to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, and your testimony that you've just given, that is part of your being sworn in. So was that testimony, part of what your sworn testimony tonight?
Yes.
Yes,
Okay, all right. Anything else you'd like to tell us?
I think that's
I
it.
think that's it. Yeah,
Okay, all right. Thank you for your comments.
Okay.
thank you.
Is there anyone else who would like to be heard? That is waiting on Zoom. If you're waiting to be heard and you
I
are.
do have someone.
You do have someone, okay.
Mhm.
And this is for the application of Werner for 10 River Avenue in Eastport.
John and Michelle.
Unmute. We're not in yet, getting there.
I don't know if you can see us.
Can you hear us or see us?
We can hear you, we can't see you.
Okay,
You can start video.
that's okay. Let's see. I don't know why.
Yeah, it's our first time
Yeah,
using
sorry.
this app. I don't know what we did wrong.
No worries.
Well, I guess, can we speak without?
If you
having a
can't
video?
figure out how to turn on the video, we can do it with audio. But unless you previously were sworn in, I just have to swear you both in.
Yes, we were
Okay.
not. So go
You were not
ahead.
sworn in. Okay, so if you can state your names and addresses, please.
John and Michelle, and we're at 35 North Bay Avenue, Eastport.
Okay. And Michelle, if you can just confirm that your name and address?
My name is Michelle Michelli,
Okay,
35 North Bay Avenue, Eastport.
okay. And you both swear to tell the truth, the whole truth, and nothing but the truth?
Yes, we do.
Yes.
Okay, thank you. You can give us your testimony.
Well, actually, the last panelist just described it, what we were talking about. We received an exponential raise in our taxes during COVID. And we've noticed changes in the neighborhood too. So they're charging us a whole lot more for a whole lot less. And seeing what was going on, I saw the last meeting. I was actually, you couldn't see me. I was just watching. It was very upsetting because to know that, well, first, 2 or 3 houses on one plot of land, whether zoning or not, it's inappropriate for this neighborhood. We came here from Bayshore and we've seen it happen over and over. And now Bayshore, you can't walk through Bayshore without, having a problem. They live in this particular house right on the
in my zoning
railroad.
board meeting, I have to call you back. Sorry.
The house is right on the railroad with the extra, places they want to zone for more housing or say that they've always been there. There's only a certain kind of people that families aren't going to move there. You know what I mean? What kind of people will be coming in? How are we going to get them through the neighborhoods with, a very narrow road and a very old bridge? And there are a lot of different things that have to be thought about. Like, have they paid taxes for multifamily dwellings for the past 40 or 50 years? Have they done that? Because it's not legal. It's out of character for the neighborhood. And,
Well,
we worry
and
about
I appreciate that, Michelle, but I want you to understand, part of this is we are reviewing what was done in terms of the issuance of a pre-existing CO. If in fact any of the structures pre-existed zone of the zoning code, then they're allowed to have what existed at that time. And as you saw in the discussions with the attorneys earlier, there was the 57 initial code, and then there was changes in 72. So we're trying to sort this all out.
Right.
But if in fact they can establish that it's pre-existing,
Right.
largely what's there is pre-existing, then it's an exception from what the code says.
And I believe Mr. Hume, was it, that said that the lady that had tried to get the variances didn't have good counsel? And that's why it wasn't done. Well, isn't that just too bad, though? I mean, I'm nothing against anybody. It's happened to me, and it was, too bad for me that I didn't have good counsel. You see what I mean?
Well, but we're here, okay?
Okay.
We're
Well-
here on an appeal, and we're listening to what everyone has to say, and we're going to
Okay.
be reviewing everything that's been submitted to figure out whether this pre-existing CO was issued correctly or not. And that's what
Okay.
the purpose of this hearing is.
Okay. We are worried about our town, and we're hoping that this comes through as on the people's side of the town. So proceed, please.
So do we.
Okay, well, anything else?
Mr. Chairman, could you inquire of those commenters as to where they live relative to this property?
Sure. Yeah, can you tell us where you reside, how close you are to the?
We are on the north side of Main Street. They are on the south side of Main Street, just a block or two over.
You're a block or two over.
Yes.
Okay.
Thank you.
All right,
It's
thank
our
you.
town, so we care about our town, and I know that a lot of people are upset about this. So.
Well,
like to
we care most, I mean, we want to hear anyone's comments, but we care most about the people who live adjacent to the property, because they're the property owners who are going to be impacted. People who live a block or two away.
Okay, well, that's good,
we'll
because
listen
we
to
are
you,
here to
but
support
it's-
the Moores. We are definitely here to support the Moores. We agree with them. And we'd like
Okay.
to see our town stay the same if we can.
Okay, very good. And I appreciate your comments.
I'm just a support animal, so.
Okay. All right. Is there anyone else who is waiting to be heard in connection with the application?
Mr. Moore.
Werner? On Zoom?
Mr. Moore.
Yes.
Can you hear me?
I can hear you now,
Hold on.
but we have some feedback going on. So that means that you may have multiple computers on at the same
They can
time.
only have one device.
I understand. Hold on.
Oh, yeah.
So use hers.
Just only one device, because otherwise that's what happens. Sadly, we already know about this.
Okay, sorry about that.
That's okay.
Okay. So I just wanted to, thank you for hearing us again.
Okay. And just also, I previously swore you in?
Yes.
I believe I did. Okay, very good. And we're seeing you on two screens at the moment.
Go on your own
Sorry.
screen. Go on your own screen.
No, I turned it off.
Oh,
Use her screen.
it's okay.
Okay.
I just wanted to thank Brett and Leah and Michelle and John for coming on. I also just wanted to let you know that after the last hearing, we had a couple of other neighbors who weren't able to be on tonight, who do live in the immediate vicinity on this block, just express their support and their disapproval of what's trying to be done. And I think Mike did a great job, summing it up, and I guess it's in your hands now. So thanks for listening.
Okay, no problem. Appreciate your comments. Okay, I don't believe, well, let me just make sure. Charlie, is there anybody else that's waiting to be heard?
No other hand.
No other hands. Okay, so Mike and Jim, just wanted to see in terms of time frame. Our next meeting is on January 20th. Want to give you both enough time to submit what you want to submit. So you tell me how long you think you need.
That would be sufficient for me. At January 20th would be fine.
I could do that as well.
Okay, so you can submit by January 20th, and then I'll let Brian make the motion, but our following meeting is February 3rd.
That would be fine. Thank you.
So with that being said, unless there's anything else, I'll move that we close the public hearing, leaving it open for written submissions till January 20th of 2022. With a written decision to follow on February 3rd.
Second.
Mr. DeSessa,
Aye.
Mr. Tudhill.
Aye.
Yes, yes,
I'm sorry, before you do that, Brian, can you make that the 21st, because the 20th is our next meeting?
Okay, written submissions, I'll amend that. Written submissions will be till Friday, the 21st of January, with a decision to follow.
Okay, thank you.
February 3rd for decision. Okay, so that's amended motion. Mr. DeSessa,
Aye.
Mr. Tudhill,
Aye.
Ms. Burgess,
Aye.
Ms. Kern. You're muted, Susan.
Aye.
Mr. Daly.
Aye.
Mr. Kelly.
He's recused.
Oh, he's accused. Okay. Chair votes aye. Thank you all for being here and for your comments this evening.
Thank you for your time.
Happy New Year.
Happy New Year.
Thank
to
you very much. Happy New Year, all.
Thank you.
See you soon.
Thank
Have a
you.
good night.
All right, item 10 on the agenda is RCF Properties LLC in Watermill. 900-100-3-2.11. This is held over from November 18th, 21 meeting. And the 2-2.
So she's trying to say that they existed in the 70s, but I thought the whole.
You gotta leave.
Yep.
Okay.
Good evening, David.
Good evening. For the applicant, David Gilmartin Jr., file for 50 Station Road, Watermill, New York. And we also have tonight with us our environmental consultant, Bruce Anderson. We have appeared before you twice. Each time you've asked us to go back to the drawing board and move the structure, which is a tennis court. We have done so, and it was submitted and given to Candace. I don't know if you have it, but I can share my screen and show it to you if that's okay. Okay, so this is, can everyone see?
Yep.
Yes.
All right. I'm not so technology challenged. Huh? The first survey that you see here is the first one that we submitted that shows the 52% rear yard lot coverage variance. And down here you see that we're 10% or 10 feet off of the rear lot line. This was the second survey that we put in where we went to 14 feet and reduced it to 48. After the first hearing, the board indicated that they would like to see them to 50%. So that's why we went to 48. We went back to the drawing board, if you will, and this is the survey that we recently submitted, which shows us at 43.8% lot coverage and 18 feet off the rear lot line. During our last hearing, I indicated that we could achieve a tennis court on this property without a variance, which is shown here. This is a site plan prepared by our architect, and it shows it in a tennis court in a conforming location where we don't need a variance. One of the things that that we believe we would get pushback is from this neighbor, because we've really moved it very close to that neighbor. So that's why we believe that while the number may be big, it is better for everybody involved, especially our neighbor to the north here, is better served by the granting of a variance. I also indicated that one of the benefits to the applicant would be a consistent road frontage here. So we saw the road last time on the subdivision, and this is with the tennis court in the conforming location, and you'll see that the house structure gets pushed up to a point where it's really pretty far ahead of and inconsistent with the rest of the neighborhood. I also did just put a red line here between the back of the house to the north and the tennis court. Showing the same picture, you'll see the extended separation. So we've achieved much more separation with the current variance request for this neighbor. And you'll also see that the front of the houses are consistent with the front yard setback. So it looks more uniform. These
Are those,
three.
Rooney, are those houses proposed? I thought these
Yeah,
lots are vacant.
I was just getting to that.
Oh, sorry.
Yeah, this house is fully built. This house is framed out. This house has a foundation put in. So these two are in process. This is built. These are proposed houses that do not have permits yet. So all of these have permits. These three do not, and this house is built. So it's one of those unusual situations, at least in my eyes, where the larger the variance, the better off the neighborhood is. The other point I'd make is the board received a letter from a neighbor in here, who complained about the variance. It seems to me that they would want to see this house pushed back some instead of objecting to the tennis court. What would be better for them is to see that house pushed back. This was a copy of the filed map that again shows the road. This is our lot. And then the separation on the lot, which is sort of squeezed us back towards the ag reserve. So the benefit here for my client is that he's able to achieve some sort of backyard here and able to keep the house back from the easement. I believe it also benefits the neighbors because again, we are getting more separation from certainly this lot by pushing it back. So I think the benefits there for our property owner, our applicant, and it's unusual, but I think it's better for the neighborhood as well that the tennis court gets pushed back. And Bruce and I can answer any questions, but that's it in a nutshell.
Okay, well, I appreciate the effort that you put into in reducing it further to 43.8%. I'm not sure where the board is on this. It's still a high percentage.
I'm okay with it.
Adam, I won't
based on what they
be
said to us
supporting the application.
I'm sorry, I couldn't hear you.
I will not be supporting the application.
I don't think I can support it either.
And I don't think I could support it either. So do you have 4 votes, Adam?
I'm waiting to hear. Mike?
I don't have an issue with the application.
Okay.
I don't have an issue with the application.
Looks like
Well,
up to.
I'm not a mathematician, but it looks like it's 3-3, Mr. Chairman.
It does. Oh, boy.
Happy New Year.
Okay, Happy New Year.
In this situation with the reserve behind it, and having driven through it, looked at it, seen where the houses are, I think we could send them back and have them come back again with another incremental number. But at this point, I'm willing to accept what's been proposed.
I have an issue because there's a place for a conforming tennis court. So, I've always been under the impression that we, give minimal approval for variances. And if there's a conforming location, there's a conforming location.
That completely undermines what your role in the process is. You're here, you take a look at unique circumstances. So you are required to apply a balancing test. It's a benefit to the
I
applicant.
know, but Mr. Gilmartin, a 43.8% is a high percentage.
Right, but a number in and of itself is not decisive in this application. There are applications, certainly like this one, where the number is high, but I believe, and I think I've demonstrated, and nobody has provided any evidence to the contrary, that the higher the number, the better for the neighborhood in this particular case. What you're referring to in the balancing test is substantiality. And the substantiality part of the test is you have to look at the totality of the circumstances. All I've heard through the 2 hearings that I've attended is that the number's big. The number's big. The number being big can't be decisive. You have to look at the totality of the circumstances. Here, what's the harm? Nobody has identified a harm in granting this variance. There's an agricultural reserve behind it, and nobody's going to be harmed in this case. Alternatively, I believe the neighbors are benefited by moving the tennis court back. We can get it in a conforming location, but it's 10 feet from the property line. Who does that
You don't
serve?
have any
Who
neighbors.
does that help?
You don't have any neighbors.
We do have neighbors. It's
It
simply not true,
doesn't
Mr.
pass
Tuttle.
the 5-part test, David,
I
as
just,
far as I'm concerned.
I just think I
I'm
proved
only
that I
one
did,
person.
Mr. Tuttle.
That's all.
Hey,
I mean, I don't know if, am I
You
not
make-
allowed to speak now because Mr. Tuttle has given his opinion? Is that the?
You're allowed to speak. You're allowed
Oh,
to speak.
stop with that, David. That's not correct. The chairman should be telling you, don't be saying that.
Well, I was
Here's what
making
it
an
is.
argument and I was
You've had
interrupted and
plenty
then
of
told.
time. You and your compadre there have had plenty of time to voice your opinion. So guess what? As a member of the zoning board of appeals, I'm entitled to voice my opinion also.
Actually lost 113 pounds.
So as I was saying, I think that we have proved that we have satisfied the 5-part balancing test here. Certainly the substantiality issue, which has been raised by the number, by requiring that the board look at the totality of the circumstances.
Okay. So apparently it's up to me. And I'm not happy about this application. I wasn't happy about the application from the start. That having been said, none of the neighbors have opposed. And I'm hearing your argument, Rooney, that there are no neighbors that are impacted by this. I think on a few occasions over the years, we have granted really high percentages of rear yard lot coverage relief when there were no neighbors. Now, there may be a neighbor in the future on the other, well, there will be another neighbor in the future on the other side. Actually, maybe that house already has a house, that property maybe already has a house on it. The one, I don't know whether it's east or west. I don't have them.
It doesn't.
Yeah, yeah. But I mean, yeah. So one can make the argument that the neighbors on either side would be impacted by this. But in terms of setbacks, it conforms to setbacks to both neighbors on both sides. And in the rear, what we have is we have an agricultural easement. We do have a fairly unusual circumstance in that we have this driveway easement running through a portion of the property. I don't like 43%. I really don't. I'm not happy about it, and I appreciate the fact that you've gone from 52 to 43 and 9% reduction in rear yard lot coverage. but in balancing the equities and considering the entirety of the 5-part test, you know, I'm going to be voting for this. And it's a hard decision for me, but I'm going to vote for it. Yeah, you know, because I want to say to my colleagues on the board, particularly the ones who are against it, that the unique circumstances of this application will run against other folks making these kind of an application for rear yard lot coverage percentages like this. I don't think I think it's a rare thing for us to have a driveway easement on one side of the property and an agricultural easement, running through the property, in fact, and an agricultural easement really in the area that would be one of the areas that are impacted. So I'm not happy with this. And really, Rudy, with your efforts and your client's willingness to make the changes to at least reduce that percentage, well below 50, but still in the 40s. I'm going to be a vote in favor. So that's where I am. Not a happy camper.
If you're not a happy camper, then you don't vote yes.
Well, I'm weighing the equities here.
We're not voting tonight, correct? We're just giving indications. Okay.
We're not voting tonight, but I want to give
okay,
Rooney, let him know where we stand. Considering the way in which the last public hearing went. Pretty much at the last public hearing, I had indicated I think I wanted the numbers substantially lower than 43% at the last public hearing, but weighing the equities, weighing the 5-part test, I'm reluctantly gonna vote in favor. So anyway, so that's where we are.
Can you stop sharing your screen, David, please?
So
thank you.
All right.
Okay, so I have the lead on this. So I'm going to move to close the public hearing for written comments January 21st with a decision on February 3rd.
Second.
Ms. Kern.
Aye.
Mr. DeSessa.
Aye.
Mr. Daly.
Aye.
Mr. Kelly.
Aye.
Ms. Burgess.
Aye.
Mr. Tidal.
Aye.
Chair votes aye. Thank you for your testimony tonight, Rudy. Have a good rest of your day.
Have a nice evening.
The decisions.
Yep. We only have 2, I think. I have one.
I have
I have a
one.
decision in the matter of the application of Gregory Lippin for property located at Suffolk County Tax Map Number 900-37428. This application is for property located at 28 Lighthouse Road, Hampton Bays. Applicant requests variances in connection with a proposed covered wood deck, 2nd floor addition, and upper wood deck. This application passes the standards set forth in New York State Town Law and the Town Code. Therefore, this board grants relief from the following provisions of the Town Code for the proposed covered wood deck on the south side of the dwelling on a non-conforming lot, 33115C, continuance for a principal minimum side yard setback of 11.5 feet where 13.9 feet is existing, and a principal total side yard setback of 38.5 feet where 40.9 feet is existing. 2, for the proposed upper wood deck, 330-83A yards to allow a deck that is higher than 1 foot above ground level to be located in the required front yard. And 3, for the proposed 2nd floor addition to the existing dwelling, 330-84D pyramid height for a proposed encroachment in the amount of 322 cubic feet on the south side of the property. These variances are for structures located on the survey prepared by Gary Benz, last revised December 8th, 2021, and the pyramid diagrams / elevations prepared by Carrie Kazel, last dated September 29, 2021. Grant of the foregoing relief is subject to such other conditions and permits as applicant has already acquired or may otherwise have to acquire for final approval of the subject premises from all departments, and including the removal / relocation of all fences to conforming locations prior to the issuance of any certificates of occupancy, or certificates of compliance.
Second.
Mr. Daly,
Aye.
Mr. Kelly,
Aye.
Ms. Burgess,
Aye.
Ms. Kern,
Aye.
Mr. Tuttle,
Aye.
Mr. DeSessa.
Aye.
Chair votes aye.
Decision in the matter of application of Pamela Keld, property located at 9 Little Cobb Road, Watermill, New York, tax map 900-114-2, lot 42. I'm going to read the requested relief at the end. At public hearing, owner David Gilmartin, attorney for the applicant, testified that the applicant wishes to add a 2-story addition to a detached garage and convert the building to habitable living space. The main dwelling is pre-existing non-conforming, and the setback variances relate solely to the existing house, not to the proposed addition to the detached garage. Meets the 5-part test, therefore, in the interest of justice and the further reasons set forth herein, this board grants relief from Town Code 330-11.2F, accessory apartment special standards for a proposed accessory apartment to be located in a detached accessory building on a non-conforming lot, to allow an accessory apartment to be located on a lot that is 29,504 square feet, where 32,000 square feet is required, 70% of the required 40,000 square feet. A principal front yard setback of 5 feet, where 42 feet is required, 70% of the required 60 feet, and a principal minimum side yard setback of 11.2 feet, where 14 feet is required, 70% of the required 20 feet. In addition, a determination is required as to whether or not the detached accessory building will be a subordinate or incidental building as a result of the proposed 2nd-story addition and the proposed 2-story addition to the existing 1-story detached garage pursuant to Town Code 330-5 definitions because of its size in proportion to the main dwelling and its use, as shown on the survey made by Squires Holden Wise, Bacher, and Smith, dated December 24th, 2021, which shows the existing and proposed structures, as well as architectural plans made by Mark C. Matthews, dated December 28th, 2021. The granting of this relief is subject to the conditions of such other permits as the applicant has already acquired or may otherwise have to acquire for final approval of the structures on the subject premises.
Second.
Second.
Mr. Kelly,
Aye.
Mr. DeSessa,
Aye.
Mr. Tuthill,
Aye.
Ms. Burgess,
No.
Ms. Kern,
Aye.
Mr. Daly.
Aye.
Chair votes aye. I think we're done.
All right. Happy New Year.
Okay. Thank you for joining us, Anthony. Motion to close?
Guys, next time.
Second.
Yep.
All in favor?
Aye.
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 Closed. Thank you, Katie.